and today is mainly about addendums. I want to stress before we get started that addendums can either help you or hurt you depending on what side you're on. So when we go through these, I will, like yesterday, give you tips and tricks and things that have happened to be aware of, but also understand that, my favorite statement is it depends, because it really does depend on whose side you're on in the transaction. There's also some new things that have happened recently with some transactions that has also led me to be very intense about some of these items when you go to write offers and accept offers. So if I seem direct, that is why, because we have been having some situations lately. The first addendum we're going to go through, it's not really an addendum, it's a disclosure. So I should write addendums and disclosures in the title, because you've got two different types of documents, and I want to clarify. Disclosures are just documents that provide information and that your client acknowledges that. So basically they're stating they have read the document and they are okay with the information on it. That is a disclosure. An addendum is an actual document tied to the contract, and it has verbiage that adds, like addendum adds, if you can remember that, addendums add information to the contract. Amendments change the contract. So you've got disclosures, you've got addendums that add, and amendments that change the contract. So disclosures are important, especially up front for buyers and sellers. And the information about broker services is the first disclosure you must provide during a true real estate conversation. It is on all our email signatures. So that is essentially, if you're in any type of communication with the client, you are providing it. It doesn't have to be signed. It's a notice that basically just has to be delivered. So do know that, of course, you want it signed, and I expect it to be signed by a client. However, you just have to provide it. You don't actually have to get it signed. They don't have to sign it. All of you should absolutely know what this document says. It is harped on in your training in licensing course. And so please know it. I'm not going to spend time on this, because that is one of the things they truly go over in your courses. Okay, actually, let's back up. Let's do the general information to notice to buyer. This is if you have a buyer. So when you have a buyer, I require, as the broker, I require this document to be signed by all buyers. This is just, again, a disclosure of information that they should be aware of when they are buying a house. So annexation, if a property is outside limits of municipality, the buyer should be aware that the property may later be annexed. That is very important, because a lot of buyers in our area are known to buy for schools, not all of them, yet a lot of them. So if you're not within the limits of the municipality, you could be annexed from that county or that city, and then your school zones change. And so that's actually happening in my neighborhood right now. They tried to annex us from the Woodland schools in the city of Conroe in a way. It didn't pass, so we didn't get annexed, but I'm sure in 5-10 years it's going to pop up again. So just know that that can happen. Appraisal. So an appraisal is evaluation of property. An appraiser renders an estimate of value as a certain date under assumptions and conditions stated in the appraisal report. Typically, a buyer's lender requires an appraisal to verify the loan. An appraisal is not the same as an inspection. As you can tell, these are just informational statements, and I want you to provide it to your client, and I actually want your clients to read it. So even if you read it to them, I have learned to narrow each paragraph down, shorten it so that they don't actually have to sit and read it, and I can read upside down. Obviously, if you send it electronically, they have time to read it and sign it, but if you're sitting in front of them, be able to summarize each paragraph and actually be able to tell them with them having it in front of them, or you can have a copy in front of you while you go through it. Brokers, it talks about the IABS. It talks about our responsibility in negotiating. We are not inspectors, and they are encouraged to hire an attorney. So that's that section. Environmental concerns, it talks about all the different options, general conditions, environmental inspections that they can do, lead-based paint if it's before 1978, mold, oak and diseased trees, and noise. Expansive soils. These are all things that have showed up in lawsuits. So that is why it has become disclosures. Inspection and walkthrough. This is the biggest one. I mean, you can read flood zones. Actually, let's go up. Flood zones. Many properties are in flood hazard zones. You obviously should check that for your client and let them know. Additionally, some properties may lie in the floodway. The buyer is encouraged to buy flood insurance regardless, especially in Texas. Inspection, repairs, and walkthrough. The buyer should accompany the inspectors during the inspections and ask questions. Brokers, agents do not possess any special skills, knowledge, or expertise concerning inspections or repairs. Honestly, this is one of the biggest sections to essentially to protect yourselves during a transaction, to make sure that they understand that we are not inspectors, that they come to us for advice, but in all reality, the inspector and other specialists are the ones who need to verify items. And the buyer and the seller should resolve in writing any obligation and timing of the complete of repairs, and that should happen before option period. And then they should do a walkthrough to verify those repairs. So all of that is stated right here. And so this document, again, is required. Please go through it. It's pretty basic stuff. I don't want to spend too much time on this disclosure because you can actually read it yourself. So should be write down a to-do list to read this document. It absolutely must be in your folder every time you submit a buyer's executed contract. So to get your file approved, you have to have the IBS and the general notice. Now, what I don't make mandatory, however, highly recommended, is the buyer tenant representation agreement. I will say that this is not foolproof. Like if we ever go to court or have mediation, TREC always, not always, 9 times out of 10 sides with the public. So if the public says anything that they weren't happy, they didn't think you did a good job, and they have proof of it, it's very likely that they're going to side with the client versus us. But this just gives a little more validation of commitment from your client. It does, in essence, help you if they at all try to go behind your back after you showing them a property, making an offer, and then the buyer and the seller go and do a deal without you. it could definitely protect your commission on that sense. Or if you did all the work and a client goes and uses a listing agent, it doesn't always mean you'll get the commission in that state, but it does help if you do have it. So let's go through this. The client's information is here. I require at least one form of contact. So I either need the address, the phone, or email. Obviously, all of it's preferred, but at least one piece of contact needs to be in there. Broker is inked real estate, and then you can put your name next to it if you would like. Our office address, your phone number, your email. So they're appointing you. So number 2 means they're appointing you to represent them and to act as representation. Number 3, so this is to help acquire, or these are just definitions, but number C is market area. So within the state of Texas, this is the area they want help representation in. Now, if you leave it blank, that means the entire state of Texas. If you put a count, a lot of people put counties to kind of make it more of a narrow, but sometimes I've even done it per address. So like if there's a for sale by owner that they want help with, or if they're saying, well, you specialize in this area, but I want to use this agent down in Katy, then, you know, depending on the situation, I may say I only do Montgomery County or and they do Harris, or I'll do the Woodlands, Conroe, whatever it is. So this section will be the actual areas that you're helping them in. If you leave it blank, it means the entire state of Texas. The term, you obviously want to make it the day you start and have them sign. Through usually 6 months is nice. Some people want it only 90 days. Some agents automatically do it a year. Really, that's going to be based on the conversation you have with them and what their expectations around buying are. Obviously, the longer the better, because then they're in a representation with you for that long. Broker's obligation, you'll do your best efforts to assist the client and assist the client in negotiation of the property and comply with other pieces of this agreement. Client's obligation will work exclusively with you in acquiring property in the market area and negotiate of property. Inform broker, salesperson, sellers, and landlords to whom client may have contacted, exclusively represents client for the purpose of acquiring property, and refer all such persons to broker. That's important. Just a little throw out this. You want to make very clear that if they go into an open house, a new construction, if they make a phone call on their own because they were driving by, even a for sale by owner, you want to let them know that they have an agent representing them. You can give them a stack of your cards and say, if you end up in an open house or end up in a new construction, you need to give them your card, and that will solidify them truly knowing you are representing them. But I would say in your buyer's consultation or in your showing, when you guys agree to work together, when they sign this document, you explain how it works, because you can't assume they know. Like, they're not in this job every day. So you act as if they know nothing and help them understand how the process works. Each person signing this agreement represents that the person has a legal capacity. The client is not a party to another representation. That's important. If they have signed this, understand that this document, there's not an actual out for a client. I'm going to jump down here because the client is in default if they do anything against this agreement. There is no cancellation clause in this document. So if they want out of this document, they have to contact the broker, technically the agent first. If the agent says no, then they move to the broker. If the broker says no, then they would have to move to Trek. Normally it doesn't get that far unless it's a really sticky situation where they did do something wrong. But most of the time, if a buyer doesn't want to work with you, it's not going to go well. I mean, they're going to not be fun to work with. You're going to be miserable. They're going to be miserable. I highly recommend not working with someone who doesn't want to work with you. However, there are those circumstances that you did everything and you should be paid, then that's when we'll fight to go keep them in it and to get the commission earned. So if a client of someone else's comes to you and says, I'm not happy with my agent, I don't want to work with them, I like you, I prefer to work with you, you can't obviously say, great, sign my agreement and let's go. What you say is, okay, if you're not happy, then this is the steps you would have to take, because technically they have to agree to let you out. You can't, per Trek's ethics in legal, start a conversation with a client and say you should fire your agent. But if they come to you and say, I want to fire my agent, or I'm not happy with my agent, I don't want to work with them, how do I get out of it? Then you're allowed to explain the process. So that is the difference. And then client should be telling you the truth. That's C. And then D is if they actually have a relocation company. So not that they're just relocating, but there's an actual company involved with their relocation process that you as an agent have to report to. So that would be what would go under D. Intermediary, you should always check A, unless I've never had anyone say no, check B, like they absolutely don't want you working with another agent in your brokerage. Now, some clients do not want you to double side a transaction, meaning that you have the listing and you are going to work with the buyer, because technically that is not a true representation. You are intermediary of the transaction at that point. However, if you have the buyer and I have the listing, then we're intermediary well, I'm the broker, so step out of that. If, like, let's say both Marias have deals, we've got one on the buyer and one on the seller, that is still true representation, but intermediary status because you're within the same brokerage. Everybody needs to know that you're in the same brokerage. You need to get approval that you can do that from the clients, but on this form, you want to check it off because you want to be able to show your clients your company's listings. I tell clients when I'm explaining it, anything in bold has been a legal situation, so I highly recommend reading it. Same to you guys, take the time to read each paragraph. I'm going through and giving you the basics of the document, but you should actually take time to read these documents in full. Competing clients. So client acknowledged that the broker may represent other buyers or tenants who may seek the same properties. It's stating that you're allowed to show those properties and the broker is allowed to do other deals with clients on the ones that they want to see as well. So it's essentially whoever has the best offer. Confidential, everything is confidential unless otherwise illegal. So unless by law we are obligated to explain, then you have to keep everything confidential within the brokerage. So like you can come to me because I'm the broker and that's what the agreement is actually stating, but you are not to share it with other people unless permission is given or it is an unlawful situation. Now, this is essentially the whole point, honestly, of this contract is number 11. I mean, all of it is to help you and kind of solidify the representation of each other. But this is why this document becomes truly important, is the broker fee. I've only ever personally had to do it once, and that was actually more on a unfortunate situation, but they just decided not to buy the house the day of closing and they walked away. And of course, the listing side's not paying me commission, so the buyer had to pay me commission. It states that the parties agree that broker will receive a commission calculated as follows. So again, this is what you work for. Typically, we see 3%. Some agents put 4. It's whatever you see fit because it's your work. The average is 3, not the standard, right? Because there's no commission standard, but whatever your standard is what goes in 1. And then the second section is rental. So we use the first box because we get paid off 1 month's rent. And that's 50%. Like I wouldn't put anything less than 50% in there. The source, so broker will seek to obtain payment of the commission specified first from the seller, landlord, or their agents. If such persons refuse or fail to pay, client will pay broker the amount specified less any amounts the broker receives from such persons. So I don't know if you guys heard, I haven't done a ton of discussion around it yet because it's not fully decided in Texas. It has been put out in a federal level that the buyer's agent commission is going to be disclosed to the public. It is being fought right now in court and they're trying to get that banned. Some states are already doing it. I don't think Texas is yet. Let's look real quick. Anyone have an address off the top of their head? No, no one. No one has a listing they can think of.
I have one.
Okay, what is it?
5202 Dunley. It's Dunle. Yep.
There we go. Thank you,
You're welcome.
Ashley. Okay, so if we go on here. Agent, I mean, is this the full report? I think that's going to show us. Yeah, that's not going to help us. I don't think it's showing it yet. Maintenance. Oh, it is. Yep. Okay. So it is now disclosing how much we get paid as buyer's agents. There is a lot of dispute around this that it's going to mess up buyer's agency. I disagree personally. I don't think people really focus on that. I mean, consumers look at pretty pictures, price, square footage. I don't know that they're even going to go and be like, oh, look, there's 3% comp buy. I don't even know that they know what that means. So I have never hid my commission. If a client has asked, I've really never had clients ask unless they feel like I'm being ripped off. So, but what it does and why they're doing it is because they want to know, and I get it, they're saying and signing something that says they have to pay the difference if they sign this agreement, and then the seller agent goes in, or the seller only offers 2%. Guess who's signing a legal document saying they're going to pay 1% to the other broker? And so I have never gone after a client, even with this document signed, for the difference. I'm going to be honest. I've never done that as an agent. It is a legal document. It is something that they would sign and have to agree to, in essence, if you did want to go as an agent. And so the broker, myself, would go and help you because it is a binding agreement. But I've never personally done it, even when I've gotten paid 2 or 2.5 commission. But there are brokers who have done it. So now they feel it is only right that the consumer sees what could possibly happen that they're signing. So I don't think it's a bad idea. They're still fighting it though. So right now it is disclosed in most states, but that may change here in a month or two, depending on what the ruling is after these other hearings go through. Earned and payable. So a person is not obligated to pay broker commission until it is earned and payable. So when is that? When client enters into a contract to buy or lease a property, client either breaches the agreement, or client breaches this agreement. So let me step back. If they breach the agreement, so if they try to cancel and the brokerage wants to go after their commission, they technically could. Again, it is rare that brokers do because Trek sides with the public so much that it is rare that buyers leave without a reason. Broker's commission is payable either during the term of this agreement or after it ends upon the earlier of 1, the closing of the transaction to acquire the property, client's breach of a contract to buy or lease a property in the market area, or client breach of this agreement. If client acquires more than one property under this agreement, broker's commission for each property are earned as each property is acquired and payable at the closing of each acquisition. If a seller, landlord, or their agents offer compensation in excess of the stated amount, broker may retain the additional compensation in addition to the specified commission. Client is not obligated to pay any such additional compensation. Notwithstanding any provision to the contrary, if client acquires a property listed by the broker, broker will be paid in accordance with the terms of the broker's listing agreement with the owner, and the client will have no obligation. Because essentially the representation agreement becomes null and void if it's an intermediary transaction. In addition to the commission, there's maybe other fees. So construction, if a client uses broker to procure, negotiate the construction of improvements to the property that the client owns or may inquire, client ensures that the broker receive a client or the contractor at the time of the construction. So this is mainly for private new construction. It could be public new construction, but they're not held to the same standard either. So this is, I would still put 3% of purchase price or sales price in here. Because if someone decides to build on a property, you technically could get paid commission. Service providers, if broker refers client or any other party to a transaction contemplated by this agreement to a service provider, broker may receive a fee from the service provider for the referral. There are some providers that do pay referrals out, so that is just disclosed. Now here is number 3. This is, I see a lot of cancellation fees put here. So if, like, let's say if client at any time cancels this agreement, or it is agreed upon to cancel this agreement, the client will pay broker $1,000 or $500 flat fee. If you personally are going to charge a flat fee, which I don't hate that idea, because your time is money, it is valuable. And I do know a lot of agents who do it. And again, they've signed it. And if it does happen, then we can go after them for that money. That's where you would put that, under other. Protection period. I put 90 days because this states that if this contract does end, then not later than 10 days, broker may send client written notice identifying any of the properties that they made them aware of during the agreement. And so then if they go and purchase those houses, then they have to pay the commission. Now, with that said, make sure you send the notice after 10 days. And I also put 90 days because if a buyer is trying to be sneaky and buy a house without you that you showed, my thought process is most people are willing to wait 30 days to save maybe $6, $10, $15,000. They may not be as willing to wait 90 days for that. Most people, a 90-day period is actually a lot for them to wait to do something. So I put 90 days. I've never had anyone fight me on that, but I've seen agents put 30 and 60, and I just don't think that's long enough. So I put 90. The county, so this is for both, this is one of the most kickbacks I make on this document. This is Montgomery County. This is not where the client lives. It's not where they're searching. It is where the brokerage is located. So this is always right now going to be Montgomery County, Texas. Obviously, if there is a dispute, we're going to go to mediation first. If that doesn't happen, then we have to bring in attorneys. And then whoever is in charge will pay the attorney, or basically whoever loses will pay the attorney fees. We are not liable for any personal injuries or loss or damage to any property that is not caused by the broker. Addendum. So these are other addendums. We obviously do general information and notice to buyers and sellers. I would advise to give them the information about special flood hazards. If it is in a flood zone, that's going to be a required document. But I would advise to get that. And then if for some reason they're waiving the inspection, I want for your protection, get a home inspection document signed. So those would be the 3 that would be involved. These 2 depend. You're welcome to go ahead and provide them if you would like. These are the 2 I require. And then this one I would require if it's in a flood zone. This I require if they are waiving the inspection. All of that is in Back Agent. If you're doing the deal and answering the questions, it will tell you what documents are required. Additional notices. These are all things, again, that have gone to court. Brokers' fees are not fixed, controlled, recommended, suggested, or maintained by the association. We do not discriminate. We are not an inspector. They should have an attorney check everything. They can get a residential service contract if they want. Oh, this is newer. Client may be recorded at a property without their knowledge. And to reduce wire fraud, clients should refrain from transmitting personal information via unsecured email or electronic communication. And you should absolutely get an attorney to review any document they sign. Any question about the buyer's rep agreement?
No.
Nope. Awesome. Okay. Now, let's just skip into intermediary because this one's fast. So this is if you are doing a deal with someone within the brokerage, whether it's a rental or a buy sell. If we are within inked real estate, this form has to be given. So the seller, the prospect, inked real estate, the property address, the date, and then will or will not appoint. So it will not if you are technically being the intermediary yourself. So if you are the listing agent and you're going to be working the buyer, which means truly you're now a transaction-based agent, then you will hit will not and everybody will sign. If you are working with another agent within the office, then you will hit will and you'll put names of who's representing the listing and who's representing the prospect. If you guys are married, because we do have a married couple, if it is like me and my mother-in-law, then I have to disclose that she's my mother-in-law. So if you have a personal relationship with the agent, that needs to be put in F. Okay. Now let's talk about the most used forms for the contract. Seller's disclosure. Has everybody signed up for Seller Shield? Ashley, you may be the only one that hasn't received the link.
Yeah, I haven't gotten it yet.
Okay, so yeah, I need to put you in the system, but everybody else should have it. And if you don't, message me, but I'm pretty sure that is just in your email and you failed to sign up for it. But I will get yours today, Ashley. Okay, so we aren't using paper seller's disclosures. I want you to use Seller Shield. However, let's just go through it real quick. If you get one from another agent, you want to make sure 100% that it's signed before you have your client sign it. This is one of the most lawsuit forms. So you really, really should pay attention to if things are checked off or not. And if they're not, I want you to truly understand what your role is. Your role is to represent your clients at the highest level. And if you're going to do that, you are going to call the other agent or email them or text them and say, hey, the seller's disclosure is missing things. Before I have my client sign, I need these fixed. Like, I would expect and hope an agent would tell me if I'm missing something, and that is our job to represent our clients. I can't tell you how many times we have to get this document fixed after it is under contract. So please, please, please do not have your client sign this unless it's fully done. The first section is if they are not occupying the property. If they aren't, approximately what date or did they never occupy the property? And then these are literally just, does the property have these items? Not if they're working or not, just are these items in the property? I do tell my clients, and we'll get it more on I guess I should that's a listing thing, but I'll say it anyway. I have them caution an error of if they truly don't know, then put unknown. Don't write no, put unknown. And all of this stuff should be filled out. If they mark that there's garage openers, how many units and how many remotes, everything should be filled out. These two right here are the most missed because they're just kind of oddly on the next page. So sprinkler system and on-site sewer, they are important pieces of the document, so they need to be checked. And the septic on-site sewer will trigger another form. So if you don't check it off, we're not 100% sure technically by the disclosures if we need that on-site sewer form. What the water supply is, was it built before 78? Because then we need a lead-based paint. What type of roof and age? Is there an overlay? And then it asks, are you aware of any listed items not working? And describe if so. Then also it asks if there's any defects in these items. And then if you answered yes, why? Are you aware of any of these conditions? You should be reading these yourself. I'm not going to go through every single line, but they all need to be checked off. And then again, if they marked yes, why? Are you aware of any equipment or system on the property, any other item that has not been disclosed? Yes or no? And then here is the flood zone information. So are they in the flood zone, floodplain? Have they ever flooded due to a natural event or not due to a natural event? And if so, explain. Have you ever filed claim for flood damage? Have you ever received assistance from FEMA? Okay, so room additions with or alterations without necessary permits, unresolved permits are not in compliance. HOA. This is another section I don't see filled out a lot because owners just don't want to take the time, but it needs to be filled out. Any common areas, any notice of violations of deed restrictions, any lawsuits or proceedings, any death on the property other than natural causes, suicide or accidents. Or on, yeah, except any condition on the property which material affects the health or safety, any repairs for environmental hazards, any rainwater harvesting system, is there a propane gas system? And then is it any located in the groundwater conservation district? Okay, I'm sorry guys, I gotta take like a 2-minute run. I gotta use the restroom. I'm sorry guys. I will be right back. Can you all hear me? Sorry, guys. I was just talking away. Section 9, seller has or has not attached a survey of the property. Section 10, there has been a lot of issues around section 10 because it says within the last 4 years, have you, the seller, received any written inspection reports from persons who regularly provide inspections and who are licensed as inspectors or permitted by law to perform. If they have, then they need to write it down and we need to attach a copy. So if they bought the house within the last 4 years and they had an inspection, you really need to track down that inspection report, because if they ask for it, you are obligated to provide it. And if they find out that you didn't, then that can get you in trouble. So please, like, be aware as the agent, if you've noticed if the house has been listed recently or within the last 4 years, then find out where those reports are. Because I mean, I like to look at those and reference and see what condition the property was in. Have they done anything? Has there been any ongoing issues? This is all stuff important for your clients. Any tax exemptions? Have they filed for a claim for damage other than flood with insurance? Have they received proceeds for damage other than flood? And do they have working smoke detectors in accordance with Chapter 766 of the Health and Safety Code, which is explained right there. And then the seller's sign, I see a lot of people miss these initials right here. Seller sign, print, and everyone initials, and then there's additional notices. This, you don't technically have to fill out, but it is nice to have these filled out for buyers. And then the buyer sign and print and everybody initials here. Seller's disclosure. Estate foreclosures, new construction, obviously don't have to provide seller's disclosures. Investors who own a rental property or flipped a property has to provide one. I see that a lot where investors think they don't have to provide one, and they do. And so absolutely do not let your client proceed without them filling it out. Third-party financing. So before I get into the actual addendums, because that was a disclosure, this is an addendum. You absolutely do not want to move forward with a contract unless all addendums are signed and executed prior to giving money. And for everybody not on this call and that will be listening to the recording, that is absolutely a priority, because not only is it happening right now in a situation, but at the same time, I've seen people not have the third party agreed to, or the HOA addendum, even more so that one agreed to, and there are actual fees involved and timelines involved. And if you as the agent allow your client to submit option and earnest money prior to having all addendums signed and executed at the same time, then that addendum is no longer valid. And if the seller doesn't want to sign it after the fact, they don't have to, even if it's checked on the contract. So please, please, please make sure that you have all addendums at the time of execution before your client gives the money. Any questions around that? Did I make myself clear?
Yes.
Thank you. Okay, so third-party financing addendum. This is obviously the different options of financing. You've got conventional Texas Veterans Loan, FHA, VA, USDA, reverse mortgage. Your lender should be the ones helping, or the buyer's lender and not yours. The buyer's lender should be the ones helping you fill this part out. So whichever financing they are, you check off and then you fill in the correct numbers based on the lender. Buyer needs to apply for financing promptly and make every reasonable effort to obtain approval. But time is not necessarily of the essence in this section, but know that if these numbers don't match what the lender can give them, you can technically cancel based on it, because it is an addendum, it's addition to the contract, and if it is not what they can obtain, then they can cancel based on it. So obviously don't go crazy and say, okay, if I don't have the lender's numbers, I'm just gonna throw out 5% here when you know the interest rate right now is around 3. Use numbers that actually seem realistic, because if they don't get that, then they technically can cancel based on it. I'm not going to go through every single line, but if you need help filling it out at that time, let me know, because the lender should tell you what the numbers are for those boxes. Time is of the essence of this section, though. Approval of financing. So the contract is subject to buyer obtaining buyer approval. If buyer cannot attain buyer approval, which means they can't be approved, which we'll get into the property in a minute, buyer may give written notice to seller within blank days after the effective date of the contract, and this contract will terminate and the earnest money will be refunded. If buyer does not terminate, the contract shall no longer be subject to buyer obtaining approval. Buyer approval will be deemed the terms of the loan described as above are available, and lender determines that the buyer has satisfied all of the lender's requirements related to assets, income, and credit. Okay, so if you're on the listing side, you don't want these days to be long. You want the least amount of time in this box, and buyers want the most amount of time in this box. So we're always in a struggle. Conventional, we tend to see people put 15 days. FHA, VA, 21 to 25. Lenders are not always reasonably timed. Like, they don't care about this addendum, to be quite frank with you, especially bank lenders. They do not care. So it is your job to make sure you watch these days. And if you don't have buyer approval within that, you are going to need to try to extend it. And if they say no, then your buyer needs to make a very important decision on if they want to terminate or not. Because if they terminate and everything else is approvable, there's no way out of this contract, and then they get denied the week of closing, they lose their earnest money. So I honestly, as the buyer's agent, try to get 25 days in here, because lenders seem to deny people the last week of the loan. I don't understand why it has to take. I've never been a lender. I get that there's processes and guidelines and back and forth, but it seems to be always the week of closing that people get denied. And so 21 days or 15 days is not never. I don't like that word. Almost never the end of the closing. It's usually 30 days. So be careful with this, because you're the one filling in these dates for your client. So if this shows up and you didn't follow through with getting an extension or help in writing, getting the client to understand that they have a choice to potentially lose their earnest money if they don't get approved or cancel the contract, then that's on you. And you may be paying earnest money back to them. The only time you would check this contract is not subject to buyer obtaining buyer approval is if you know your client is planning to pay cash if they can't get approved. I have done this twice. I've had two buyers who were in multiple situations. They wanted to finance because financing right now is so cheap. But they also were willing to pay cash if they had to. So to basically make this non-contingent to anything but appraisal for like an FHA buyer, you could put buyer not subject to buyer approval, but it is rare that you would do that. Now, this is where it really comes in. B for property approval. This is for the life of the contract, or excuse me, not later than 3 days before closing. So 3 days before closing, the lender has to determine whether the property does not satisfy lender's underwriting requirements. This is what we're going through right now with one of our deals. The lender on our listing, so the buyer's lender deemed literally 4 days before closing, 4 days, that the property was not appraised correctly, and so it is not deemed approvable, and so the buyer could terminate. Now buyer didn't want to terminate, but they said that if we can't fix it, they're going to terminate. So we got the written notice in time. They technically could cancel if they wanted to. We're trying to make it work. We think we're making it work. But again, everything seems to happen the week of closing on most deals. And so just be prepared to follow these timelines, to understand these timelines so that you can appropriately advise your client. Any question about number 2? Because this is the main piece of this document is right here, is A and B on number 2. Nope. Okay.
I have a question.
Sure.
So for A and B, you would have to choose one or the other, or you could not check that box at all.
So you need to choose if your client is getting any of these type of financing, you want to check either 1 or 2 under A. Typically, you're going to check number 1 and fill in your number of days because most clients want it subject to buyer approval. That's mostly the point of financing. But B is automatic. Like it is automatically in the addendum, so you don't have to check anything off for B.
Okay.
Yep, good question. Number 4, if your client is FHA VA, this is a required provision per the government. And so basically this is just jargon for HUD putting the offer price. So whatever the contract price is. So if you offered 300,000 and that's what it's agreed, then you would put 300,000. It's not the financing amount because that goes up here. That goes right here is how much they're financing. This is the actual contract price, and it states that it's just an added protection that if the property doesn't appraise, for whatever reason, it doesn't appraise, the buyer can cancel. And then this just states that the lender is allowed to release information for the status of financing. Okay, this is a third party addendum. That is if they are getting a loan other than seller financing or an assumption or cash. Obviously, you don't need that addendum if it's cash. Okay. Addendum for subject to mandatory membership in a property owners association. Basically, if it's in an HOA. You put the address, you put the HOA name and their phone number up here. Now, this is not used with condo contracts, just for 1 to 4, unimproved lots, farm and ranch, anything that's in an HOA that's not a condo. Okay, so this document has bit some people in the butt before, so I want you to pay very close attention, especially as a buyer. Again, it depends on whose side you're on and what you want to have happen. So if you're the buyer's agent, subdivision information means a current copy of the restrictions applying to the subdivision and bylaws and rules of the association and a resale certificate, all of which are described by the section with the property code. So you would check either 1, 2, 3, or 4. Now, if you're a buyer's agent and you want to cancel based on restrictions, the resale certificate, anything to do with the subdivision, which is very, very important for clients who have specific desires around doing something to their property, such as adding pools, even as subtle as putting up a playground or a trampoline. Some subdivisions don't allow them. And so that if you put number 4, which is what most listing agents will pre-check off for you and post, I do it. I post number 4 and I say, I want this addendum filled out, and I have my agent already, or my list sellers already sign it. But if you're the buyer's agent, and I mean, honestly, you really want to have the right to cancel based on documents, because that gives you another out, but someone's got to pay for those. And so I just want to make very clear, because it has happened in our brokerage, that without number 1 or 2 checked, if you get the deed restrictions and you didn't fill out number, what was it on the contract? I gotta pull up the 1 to 4 real quick. Because remember yesterday we had stated that you wanted to put if there was a special use. This is also referencing this addendum. The right, nope, sorry, I'm making you dizzy. Right here under D, so 6D objections. This is important to fill out too, with what they cannot do with the property, because that reference to surveys and to the title commitment. But then also, if you find out that the HOA won't allow it, not just the survey or the, oh my gosh, where am I going? Not just the survey, but the actual HOA doesn't allow it, then you're in trouble if you didn't get the documents and be allowed to cancel based on it. So 1 would be the seller shall obtain and pay for and deliver. 2 is if the buyer shall pay for and deliver. And 3 is the buyer has received and approved the documents before signing, and they do and do not require an updated resale certificate. If buyer requires an updated, seller at buyer's expense shall deliver it to buyer within 10 days. Or number 4, buyer does not require. 9 times out of 10, title companies require resale certificates. So someone's going to pay for that. And if A, doesn't get checked, like if you don't buy the deed, get to be able to cancel based on the subdivision information, then E supersedes it. So if you're checking number 4, then title is going to come down here and see who's going to pay for it, which it's either going to be buyer or seller. So understanding this agreement, I want to make very clear, if you don't check 1 or 2 and you haven't received and approved the subdivision information already, then your client can't terminate based on the HOA docs. Okay, so if you check number 4, the buyer doesn't require them, then the title company is going to jump down to E and see who's going to pay for it anyway, because title companies, when there's an HOA, require the resale certificate, and so someone's got to pay for that. So that's a negotiable item. If you're the seller, you probably want the buyer to pay for it. If you're the buyer, you want the seller to pay for it. So it depends on what market we're in. That also, that's the cap that I'm talking about. I have it on my notes to find out how much that is and then let you guys know, but I believe it's $295. So someone's going to be paying for that, and usually they pay for it up front, not at the end of closing. But if your client wants to do something like Airbnb, put a pool, put a playground, put a trampoline, have 10 dogs, like the Woodlands only allows 2 dogs per property outside at one time. So it's like anything like that, you want to just either try to get the seller to pay for the docs or convince your client that it's going to protect them if they spend a little extra money to verify if they're allowed to do something or not. Any questions about A and E right now?
Is there like an average amount of days that you would put?
So if I'm asking the seller to obtain it, I'm gonna say 10. Most HOAs take at least, they say 5 to 7 business days. Since this is actual calendar days, I always put at least 10 because I know that it's unrealistic, and I'm not trying to be one of those agents that say, let me find every loophole in the contract. I mean, if you want to put 5, you can, but it's very highly unlikely that an HOA is going to get you those docs in 5 calendar days. It's normally 5 to 7 business days, which turns into 10 calendar days because of weekends. And so on 1, I put 10, and 2, I put 20. Because if my buyer's going to pay for it, then I don't want to have to pay for them right away unless my client wants me to. But normally I want to get through inspection and option period and then order the docs so that they're not paying for things that they don't need if they cancel. Does that make sense? Perfect. And then if the seller does pay for it, they can use that if it's within 90 days of the date that they were received, the title company will use the same documents. So they can, if for some reason they cancel and they had already paid for them within that week, a new buyer can use those documents. So then you could check off number 3. And then an updated resale certificate may be required, and that's based on the title company at that point and how fast you close. If anything changes within the HOA while you're under contract, the seller is obligated to give notice to buyer, and the buyer may terminate with that new information. Fees. So this is the transfer fee. So 99.9% of HOAs have figured out that they can charge transfer fees. And they're typically anywhere from $50 up to $500. So if you're on the buyer side, the listing side, you should absolutely verify. On the buyer side, you should absolutely verify, because whatever you put in here, if it goes beyond that amount, so this says that the buyer will pay all the fees that the association pays with the transfer, not to exceed blank. So if you put $300, and you're the seller and you find out it's $500, guess who's paying that extra $200? The seller. So you need to be sure as a listing agent and a buyer's agent that you verify these fees. We do find that we have the buyer pay the transfer fees here. Like, I don't see this usually blank if there is a transfer fee. But I mean, technically it's a negotiation. So if your client was adamant of paying no HOA fees when they buy a house that they can avoid, then you would put 0, because then the seller would have to pay them all. Now, this isn't buyer mandatory fees according to the HOA. So I don't know how many of you have done a deal with an HOA yet. However, HOAs send back a form to the title company and says, these are the list of fees that you must collect at closing or you cannot close. And they have come up with all these new fees. Like there's one called reconciliation fund fee required to a buyer per the HOA. I'm thinking of the closing that happened. And so it was like $1,000. And if they didn't get that from the buyer at closing, and yeah, you could come back to the seller and say, hey, there's this fee. Were you aware of it? And in this particular transaction, no one was aware of it. Like the owner wasn't told. I called the HOA because we sold in January this last year of 2021. And they said, oh yeah, we just passed it. We're sending out notices. And so we didn't make the buyers aware of it. The sellers didn't know about it yet. And it was said that the buyer had to pay for it. Now you could say, okay, well, will you pay for half and this and that? But being a seller's market, they paid for it, or else you weren't going to close. So as a listing agent and even as a buyer's agent, if there is a big HOA, like not like mine, I live in Carriage Hills. Our HOA is $250 a year. There was like a $50 transfer fee. Those HOAs don't tend to charge as much. But these big HOAs that have like Cinco Ranch, for example, in Katy, they have massive amount of HOA fees, and each one of their sections have additional fees. So I would highly recommend finding out all those fees before your client goes into a contract. Questions? Nope. Okay. Non-realty addendum, this one's quick. You have to have, so in the court of law, and I'm not an attorney, but this is what I've been told, there are goods, and this was actually in our test, there you have to have a transfer of money or some item for goods, for a good or service. So a non-realty addendum is attaching anything that's not considered a fixture that you're negotiating. So such as refrigerators, maybe a piece of art, the blinds, a TV, a stereo system, furniture, anything like that. But it won't uphold if you just put 0 or an A. So if they come back and they take the furniture with them and you put 0 in here, there's a chance that you've lost the furniture because you put 0. So it has been said to put at least $1 because there has to be a transfer of some, because it says for an additional sum, not it's free for this contract, it's an additional sum of. So you have to at least put $1 and specify each item carefully. It does recommend to put model numbers, serial numbers, location, and other information. There has been situations where, guys, do you mind if you hold 1 minute? This, my landlord, James, has been calling 3 times.
Okay.
Sorry, guys, 1 moment. Hi, James. Sorry, I was teaching. Yeah, I talked to Alex. So an agent went to show it and the key was gone out of Sharpton. And so I called Alex first. He didn't answer. So I called you, but then he called me back. He did take the key out because he said that there was a ton of debris and he didn't want anyone to get hurt. So I talked to him and I'm stopping showings for just the day and he's going to have it cleaned up by the end of day and I'll make it back showable. He's like, I don't want anyone to get hurt. So, okay, thanks. Bye. I hope no one's showing Sharpton today. Is anyone showing Sharpton today?
No.
Okay.
What
It will
happened?
be, they are remodeling the bathroom, actually. So James, the owner, had wanted me to continue showing it and just put a note. And then this morning someone went and the key was gone and the contractor took the key with him because he didn't want to leave it and someone get hurt because I guess he had it all pulled out and stuff. And so I just needed James to know that I'm stopping showings today due to that. Okay. So there has been a situation where a client or agent, we don't really know who masterminded it, but they took the fridge and replaced it with a different one. And if you just put refrigerator and kitchen, it could be hard to prove if it's the exact same fridge. So if you have a client who wants a certain item, I would advise having a picture of it, especially with appliances, taking a picture of the model number or the brand at least, and being specific on this document. A lot of lenders don't like this document because it can mess with the financing and the appraisal. So especially FHA and VA, conventional is less of a concern, but if it's VA, FHA, we have seen this addendum be signed but not sent to anyone, which I don't recommend. What I do recommend is doing a bill of sale and doing it outside because this is personal property. That's different. There's no agreement for additional like terms of a contract, but a bill of sale is between 2 people agreeing for service or services or goods. And so I do bill of sales more than I use non-realty addendums unless it's cash or conventional loans. Okay. Addendum for sale of another property. This is the one that's getting sticky right now. This is very important. If your client has to have it contingent on the sale of their property, you need to make sure this document is filled out and signed. So it says the receipt is contingent upon the buyer's receipt of the proceeds from the sale of the buyer's property at their address on or before the date. I put the closing date of their house, not necessarily the closing date of this contract, but if the contract is closing, this contract is closing, let's say February 10th, and the house closes January 31st, well, I'm gonna put January 31st because that's when the house closes. And then if you need to negotiate the extension of that at that time, or you could maybe push it out to like February 5th, just to give you some buffer. Now this document gives them the right to keep the house active or pending continue to show, because they're allowed to accept other offers. So if they get another offer, the buyer has to be notified, and then seller requires buyer to waive the contingency on or before blank days after seller's notice. Otherwise, the contract will terminate automatically. So I normally do 3. You could do 5, but again, I don't like to give clients too long to make decisions. And so, yeah, that could happen, and it has happened where sellers have gotten better offers, they want to take it, so the buyer would have to waive this contingency. If they have to have the proceeds, then they're really needing to make the decision if they're willing to take that risk. C, buyer may waive the contingency only by notifying the seller of the waiver and depositing blank with escrow agent as additional earnest money. I put NA in that, or 0. If buyer waives the contingency and fails to close and funds solely due to buyer's non-receipt of proceeds from buyer's property described, buyer will be in default. Make sure this document is 100% signed and received if your client has to have the proceeds, and it is important to them that they sell their other house to buy that other one. Any questions about that? Lead-based paint. This is a disclosure. It's an addendum, but it's also a disclosure. So if you're the buyer's agent, you do not sign this document without it being filled out by the seller. And if you're the seller, you need to provide this at the time of execution, prior to execution, or they could cancel. So you have to have it completely filled out. B, either they're know that there's lead-based paint, or they have no knowledge. Either they have had a record and report of lead-based paint, or they don't. That's the seller's duty. And then they sign and we sign. Then the buyer either waives the right or wants the opportunity to inspect the property, or they waive their rights, and then the buyer acknowledges that they received these copies of any records and the protect your family from lead-based paint. If you have a property 1978 or before, you need to provide that protect your family from lead in your home disclosure, which is in .loop. Everybody signs, even the agents. And this is the biggest thing I find, is that the agents don't sign, or that the buyer has checked stuff off and the seller didn't even check anything off. If you're the buyer's agent, you do not sign this without it being filled out. On-site sewer. So that means a septic or well. It is again a disclosure, so it needs to be filled out from the seller side first. So what type of septic tank, type of distribution, location, installer, age, is there a maintenance contract? When was it pumped? Is there any issues? Any concerns? Is it necessary for a buyer to have or it may be necessary to have a permit to operate? In Montgomery County, there is no permits required for on-site sewers. I learned that recently. I'm not 100% sure about Harris County. And then everybody signs. Again, the seller, you need to provide this from the seller side before execution, and buyer don't sign this. I mean, you can't sign it. There's going to be nothing filled out, but you want this prior to signing, but technically it would give you an out if you don't from the buyer side. The last one that's not on here that I need to add is the MUD or water district form. Oh, Maria, did you ever find out from your daughter if there's a map?
I thought I was muted and I wasn't. She said, when I asked the favor from the friend, she says that we can pull it up online ourselves because she didn't want to give us the wrong information. So
Did she give us the address?
yeah, I know. I'm gonna text another person and see if they'll help me. I'm actually going over there today to leave my flyers at the thing, so I'll see if I can talk to somebody that can help me.
Awesome. That would be a huge help. Because I've looked for it and I have not been able to find it online.
Okay, hold on. Let me write this down. I have moved for a second. Since there's only girls, I had to go pee. Okay, exactly. What am I asking for? One more time.
So we need, is there a map of the boundaries for the whole or part for the municipalities? So the whole or in part of the municipality map. There's like the corporate, the extraterritorial jurisdictions. Are they located in the whole or in part of or not at all? I feel like there has to be a map. Like, I don't know.
Oh, I forgot you're recording this.
I wasn't gonna say anything. You had already said it.
Sorry. Okay, I got it. I'll see if I can get it for you today.
Okay, awesome. So note, if this is not in, I'm going to be honest, we're using this right now as our get out of contract card because the listing agent did not provide this disclosure prior to execution. And it says this notice should be completed and given to prospective purchaser prior to execution of a binding contract, should be executed by seller and purchaser, and should be attached as a separate portion of a purchase contract. In the contract itself, it says it needs to be executed. And so if it's was never provided because it's a disclosure, then we can get our terminate and get our earnest money back. So exciting for us, not so much on the listing side. So if you're on the listing side, you better have this posted on MLS when you list the property. Where do you find this information? You find it on Matrix. So this is not a good, let's go to my office listings, Here we go. So let's pull up this one. No, that's a rental. Where's it? I need one that's actually in a MUD, and I don't think any of these are. So let's go to my office pendings. This one's in a mud. Okay, so we're gonna use this one. So there's a couple ways to find it. It should now under tax. It will tell you spring under jurisdiction. It will tell you Spring Creek mud. Now, this one doesn't actually give you the information that you need. So what you really need to do is click on the tax account number. You can see that, right? The tax info. Yes, one of you.
Yes.
Thank you. So under the tax, the realist, it will actually give you the direct link to fill out the mud. So Spring Creek UD, Montgomery County, tax rate, tax year, bonds issued. So it literally goes in order to the document. So you would put the name of the mud, you would put the 0.99 here, the same number here. I think it was 0.99, right? And then you put the first big number here, the second big number here. According to every title company I've talked to, you're always going to put NA because this is not an option for us, our area. So number 2 is NA. Now this is what I'm attempting to get Maria to find out. Because we need to find out, is it located in whole or in part with the corporate boundaries of the municipality? Notice for districts located in whole or part of in the extraterritorial jurisdiction of one or more home rule municipalities, or notice for districts are not located. What I have done is called the water district and just asked. Then, so whichever one you choose, if you put an X here, then you would put the city of whatever. So in this case, it's City of Spring here. If they're going to choose number 2, then you would put the City of Spring here. So that's how they are. It says complete A, complete B. So that's how it works. This is the legal description. Everyone signs, and then down here is the year that information is updated. So tax year is 2021, so it has been updated, and you would put 2021 here. Real quick, this is the last document we're going to go over right now, is the amendment. So the amendment changes the contract. So be well aware that whatever this does, it supersedes the contract. So it better be right because you're changing it. Address of the property. So if you're changing the sales price, then obviously you need to change the financing and the cash too. So you would fill out all of these or just the cash if it's a cash deal. Number 2 is if you're negotiating repairs. Now, a lot of times you can't fit all the repairs in here. So you would put C repair exhibit, or I usually say, sorry, C exhibit A repair amendment. And then I would attach it with this. If it all can fit, then I would make it fit. But if it doesn't, then I attach just an exhibit A Word document with all the list of repairs. I'm going to put on a class about writing repair amendments because that's very important. Less is like, you got to be very specific with those. So I'm going to hold a class for that. The date in paragraph 9, that's the closing date. So you would be changing the closing date. That needs to be done prior to your closing date ending. Because once your closing date ends, there are some loopholes for it to automatically extend, but sometimes it doesn't. So you want to make sure this is signed prior to it ending. The amount in paragraph 12A, like I referenced yesterday, this is the total new amount. So if you had 2,000 on the last contract and you negotiated 2,000 in repairs, it should be $4,000 here, not 2,000, because then you're only getting 2,000. You have to add it. I've seen that mistake as well. The cost of lender required repairs and treatment as itemized on the attached list will be paid as followed by seller and blank by buyer. Buyer has paid seller an additional fee, option fee of blank for an extension of the right to terminate on or before 5 p.m. on this date, and it will or will not be credited to the sales price. This is obviously an extension to the option period. Buyer waives the right to terminate to the contract for which the option fee was paid, and the date for the buyer was given notice cannot obtain buyer approval as set in the third party financing as it changed to blank. And then if there's anything that is not on here that you're going to be negotiating, for instance, a big one that goes there is like if someone is getting added to the contract, is someone is being removed to the contract, or if maybe you didn't put their legal name the first time, that would be written under number 9. This is a brief overview. There are more addendums than this, but these are the main ones used every day. Am I missing any that y'all can think of? Maria? I don't think so.
I don't think so.
I will say, I'll add just real quickly because I know we're over. The termination. So if you do decide to terminate the contract, this is a one-way document. So once you send it, you're technically terminating the deal. So you put the address, you put their names, and then you check one of the options. So main options are here, 1 through 7. But if you're canceling due to another, like failure to provide the mud, that would be put in number 8. But otherwise, these are already options for you. There is no seller signature. So be aware that once you send this notice is not an election of remedies. You're not negotiating after this. Now, do people negotiate after this? Yes, it does happen all the time. But from our standpoint, if you send this form or if you receive this form, it is canceled. Like you have terminated the deal. It is a one-way document. The two-way document is the release of earnest money. So if we get into the point where we're fighting for earnest money, the other side may not sign this. So the termination is one way, but the release of earnest money is a two-way. So it has the property, who's holding the money, the amount, and who it's going to. And then everybody signs, buyer, seller, listing broker, and buyer broker. And so without this signed, title will not release the funds. If we have to go into mediation or any type of dispute, then the brokers don't sign this. So essentially that's typically who's the last people to sign is the last broker. those are now, the main addendums and additional. Thursday, we are going to go over the listing documents. So there may be some overlap, but I won't have to go through everyone in detail. But on Thursday, we will do listings. And then next week, I'm going to hold rental side. So we should be able to get through both because the rental listing is pretty similar to the actual listing. And then we'll go through a lease as well next week. Any questions? I'm realizing I need a full 2 hours for these classes, not an hour and a half. Thank you guys for staying on.
You're welcome.
All right. Well, if you have any questions outside of this, feel free to call me.
All right. Thank you.
Thank y'all. Bye.
Bye.